Your three numbered sections are essentially attacking the same weakness. The complaint keeps asserting a conflict without identifying a legally recognizable one. Here's the straight analysis. Number 26, alleged conflict of Deputy County Attorney Arad. Open quote. Plaintiff alleges that, despite that conflict, Arad did not withdraw or recuse. Close quote. 1. What conflict? None is clearly identified. A legal conflict of interest requires representation of adverse parties in the same or substantially related matter, or a personal interest materially limiting professional judgment. From what is described, AROD represents Larimer County and its employees in their official capacity. Plaintiff sued the county. AROD defended the county. Communications were routed through him after litigation began. That is standard government defense representation, not a conflict. No conflict between the state and AROD, or AROD and plaintiff correct, based on what's written. AROD is employed by the county, acting within his official role, defending the county after notice of claim and filing. There is no attorney-client relationship between AROD and plaintiff. Therefore, he owes no fiduciary duty to plaintiff. He has no duty of neutrality toward plaintiff. His role is adversarial once litigation begins. Calling that a non-neutral conflict misunderstands the structure of government litigation. 3. Plaintiff sues the county. County attorney defends it. That is exactly how it works. When a notice of intent to sue is filed and a lawsuit is initiated, the county attorney's office typically takes over communications, centralizes responses, acts as legal gatekeeper for county employees. That is not misconduct. That is litigation protocol. Routing communications through counsel once litigation begins is standard practice, risk management, required to prevent unauthorized statements by county staff. The core legal problem in plaintiff's allegation. The complaint appears to assume, open quote, if the county attorney responds to me while also denying my claims, that is a conflict. Close quote. That is incorrect. An attorney defending a client is not required to be neutral, is not required to facilitate an opposing party's case, is not required to withdraw simply because the opposing party objects. Unless plaintiff can show, AROD represented both sides, AROD had a financial interest in Thayer personally, AROD acted outside official capacity, there is no cognizable ethical conflict. Bottom line, from what you've laid out, there is no articulated conflict. There is no improper recusal issue. The county attorney defending the county after litigation begins is routine. Gatekeeping in legal matters is literally part of the job. The allegation reads conclusory rather than fact-based. If you want, I can also break down whether counts 23-26 taken together would likely survive a Rule 12b6 motion.